Greetings, Professor Nadia. In my presentation today, I will aim to analyze how the structural differences between monist and dualist systems impact the manner in which multilateral environmental agreements, also known as MEAs, can be harmonized with domestic legislation, suggest recommendations for improvement to increase compliance with these agreements across various legal systems, and finally, I will conclude with an overview of the legal principles discussed and the suggestions provided. To preface, multilateral environmental agreements are international agreements that are signed with the purpose of promoting international cooperation to tackle and resolve environmental issues like climate change, loss of ecosystems, and pollution issues. Now, an interesting concept to consider when examining multilateral environmental agreements is the prisoner's dilemma. This is a situation in which two suspected criminals are arrested and placed in separate cells. The police tells each of them that there is not enough evidence to convict the both of them, and if either of them confesses while the other stays silent, the one who confessed will be released while the other receives 10 years in jail. If both of them stay silent, each of them will face 1 year in jail. However, if both of them confess, they will both receive 5 years in jail. Hence, the most mutually beneficial solution, or to be exact, the least mutually damaging solution would be for both of them to cooperate and stay silent in order to receive the 1 year prison term. This line of reasoning can be applied to multilateral environmental agreements in that multiple countries will have to cooperate to achieve a mutually beneficial solution that resolves environmental issues, as the cost of a single country in attempting to resolve environmental issues would be too great for minimal results. I believe it is important to bear this line of reasoning in mind as we navigate it through the remainder of the presentation. Now, in order to understand how the structural differences between monist and dualist systems impact compliance with multilateral environmental agreements, we must first understand what monist and dualist systems are. Within the sphere of international law, there are traditionally two widely accepted models or theories that most modern nations tend to follow: monism and dualism. Monism states that the sphere of operation of domestic and international law are interconnected. According to the traditionally monist approach, international law ought to be automatically incorporated into domestic law without any additional act of adoption, such as the state passing an act of parliament. After it has been incorporated into the domestic legal system, it then becomes part of the domestic legal order and is a valid source of law that will be applied by the courts if a case at hand calls for it. Should there be a conflict between international law and domestic law, international law will prevail. This expands into the doctrine of incorporation, which states that a rule of international law becomes part of municipal law without the need of incorporation or adoption. The incorporation into domestic law is automatic unless there is some municipal law which precludes the use of international law by the domestic court. To illustrate, an example of a monist country is Germany. Article 25 of the German Constitution of 1949 provides that the general rules of international law are an integral part of the federal law. This expressly provides for the automatic adoption of international law into Germany's domestic legal system without the need for additional machinery of incorporation, showing that should Germany sign an international agreement with certain obligations, those obligations would then become domestic law and enforceable in domestic courts. Another example is Article 28, Sub 1 of the Greek Constitution, which states that the generally acknowledged rules of international law shall be an integral part of Greek law and prevail over any contrary provision of the law. On the other hand, dualism states that domestic law and international law operate in separate and distinct spheres and that international law is not automatically incorporated into the domestic legal system. As they operate in separate legal spheres, the only mechanism for the translation of international law into domestic law would be the regular domestic lawmaking process. After the international law is incorporated into the domestic legal system, it becomes part of the domestic legal order and may be applied by the courts if and when the case at hand calls for it. However, distinct from monism, the newly adopted international law will not prevail over domestic law in the case of a conflict between the two. Dualism as the model stresses the supremacy of domestic law over international law, and should there be conflict between the two, domestic law shall prevail. Now, this expands to the doctrine of transformation, which states that the rules of international law do not become part of municipal law unless they have been expressly adopted by the state. Under this doctrine, international law may be transformed into domestic law through various methods, such as the passing of an act of parliament. An example of a dualist state is the United Kingdom. In R.V. Keane, there was no domestic legal legislation which provided for jurisdiction over the 3-mile territorial sea around the coasts. This jurisdiction existed in international law, but on whether this could be applied domestically, Cockburn CJ stated, Nor, in my opinion, would the clearest proof of unanimous assent on the part of other nations be sufficient to authorize the tribunals of this country to apply, without an act of parliament, what would practically amount to a new law. Hence, it may be seen that the courts are reluctant to apply international law in the absence of incorporation by an act of parliament, showing that the UK is indeed a dualist state. Next, allow me to consider the challenges to complying with an MEA for both monist and dualist systems. The biggest legal challenge faced by monist systems when complying with MEAs is the lack of domestic adaptability. International agreements tend to be broad in nature and are not tailored to the specific legal, social, or economic context of individual countries. An example of this was South Africa's handling of its obligations under the Rome Statute of the International Criminal Court, also known as ICC. During Sudanese President Omar al Bashir's visit to South Africa in 2015, he was subject to an ICC arrest warrant for alleged war crimes and genocide. Despite being a party to the Rome Statute, South Africa failed to arrest him, citing diplomatic obligations and regional political considerations. The government argued that arresting a sitting head of state could destabilize relationships within the African Union, where there was significant criticism of the ICC as disproportionately targeting African leaders. This shows how the Rome Statute of the International Criminal Court was too general, not considering the political situation in South Africa, whereby the government did not want to destabilize relations within the African Union. This leads to the biggest practical challenge faced by monarch systems, which is capacity limitations such as clashing economic priorities. A notable example is Brazil's difficulty in implementing the Paris Agreement on climate change. However, fulfilling its commitments under the Paris Agreement has been hindered by the fact that Brazil is heavily reliant on agribusiness, which accounts for one of the largest shares of Brazil's GDP. This reliance on agribusiness drives deforestation, creating a conflict between Brazil's economic survival and international obligations. For developing countries who are aiming to develop into the upper middle to high income range, a drop in their GDP may not be a worthy trade off in order to fulfill economic and international obligations, leading to these obligations not being met. On the other hand, the biggest legal challenge faced by dualist systems when it comes to complying with multilateral environmental agreements is that there may be delays in incorporating the international agreement into domestic law, possibly due to political resistance during the lawmaking process. In dualist systems, since domestic and international law are treated as operating in separate spheres, international agreements have to be transformed into domestic law, and this can lead to delays in the lawmaking process. On the need for incorporation, the case of Chung Chi Chung v. Crown stated that international law has no validity except insofar as its principles are accepted and adopted by the UK's own domestic law. The clearest example of when delays were faced in incorporating international agreements into domestic law is the UK's handling of European Convention on Human Rights. The UK signed the ECHR in 1951, but as it was a dualist state, the treaty did not become enforceable in domestic courts. It was not until the passage of the Human Rights Act 1998 that the ECHR was fully incorporated into UK domestic law. This significant delay was due to political debates about the sovereignty of Parliament and concerns about the judiciary's expanded role in interpreting human rights. The biggest practical challenge faced by dualist systems when complying with MEAs is that there may be economic and political resistance faced when incorporating the international agreement into domestic law. Compliance to MEAs may require significant changes to domestic policies, such as adopting cleaner technologies, enforcing stricter environmental regulations, or transitioning away from intensive industries. This could be a matter of contention in countries that are still heavily reliant on fossil fuels for their energy needs, or have large carbon intensive industries. Resistance from stakeholders involved can slow the legislative process. Now, when the electorate is evenly divided across party lines and neither party holds a large and secure majority in the legislature, legislative battles become highly partisan. In such situations, the majority party then works hard to establish its own policy successes and to deprive minority party lawmakers of legislative successes. The debate that ensues in doing so can delay the incorporation of multilateral environmental agreements even further. Now, the penultimate stage of the presentation will focus on recommendations for both monist and dualist systems to alleviate the issues and problems mentioned earlier. Firstly, for monist systems, it would be for the government of the day to push for a consensus with the other signatories that the obligations of the treaty cannot be met instantly or in the short term. Under this recommendation, the government of the day would not seek to adapt and apply the provisions of the international agreement to domestic law instantly, and possibly face a gap between the requirements of the agreement and the domestic political, legal, or social situation. Instead, the domestic and suggested course of action would be for the government of today to come up with a long term plan of gradual but consistent implementations for the provisions of the international agreement. This would allow the nation to gradually increase their capabilities to match the obligations of the international agreement, thus ensuring better compliance with it. It would also reduce any potential political or economic resistance that would be encountered when applying it, as the change would be gradual and only made when the state is actually capable of meeting the requirements. On the other hand, for dualist systems, the recommendation would be for the government of the day to pass legislation that would provide guidelines on how to incorporate international agreements and exactly what should be incorporated. The proposed legislation would potentially include a timeline for incorporation and debate, a method for determining how much of the agreement should be incorporated, and some flexibility for the agreement to adapt with local circumstances. Doing so would create a so called template when dealing with the incorporation of MEAs into domestic law and would greatly shorten the time needed for debates on a matter of contention into the agreement. This would also reduce any political pressure that would arise as a result of the disagreement or disapproval with any parts of the content of the MEA, thus also reducing any obstacle or political challenge to compliance with the agreement. Additionally, this would also provide the state with some flexibility to adapt the circumstances and requirements into their local context, ensuring that any change that occurs would be gradual and not harmful to the nation itself. Thus, in conclusion, the opposing views on whether domestic and international law are separate forms the crux of the differences between monist and dualist systems. These differences impact compliance with multilateral environmental agreements by making the agreement subject to legal debates for dualist systems or making it hard to adapt to local circumstances for monist systems. The best recommendations that I could provide would be for such agreements to be adapted gradually, with a clear manual for implementation alongside efforts made at easing the harmonization process with the domestic law. Thank you, and that will conclude my presentation for today.